on the call and is supposed to be on another meeting called by the Chief Justice. So I want to accommodate him as best as possible. Those items are 2019-001, 2019-004, that I believe is actually not going to be addressed today. I think it's going to be tabled for today, and 2019-014. Judge Gold.
Thank you, Justice McDonald, and good afternoon, everybody. And thank you for taking me out of order. The three proposals that I'd like to report on are those that were sort of handed off to me by Judge Alexander when she was elevated to the appellate court. The first of those proposals is one that was put forth by the victim advocate, Natasha Pierre. Since I appeared before this committee last month, I've met twice remotely with Ms. Pierre and also with Rich Colangelo from the Chief State's Attorney's Office. Based on those discussions that the three of us have had, Ms. Pierre has asked that her proposal either be marked off, subject to her reclaiming it if she finds the need to do so at a later date, or tabled for a number of months. Ms. Pierre was supposed to be on the call as well today, but she's apparently lost internet service at her home in the storm yesterday evening. And she called me, and I believe also emailed Justice McDonald about her the reason for her non-appearance today. But Ms. Pierre has agreed to have this rule go off for the time being because on the discussions that I've had with her and Mr. Colangelo, we've agreed on a practice and protocol which Ms. Pierre feels will give her office sufficient assurances that the prosecutors are fulfilling their statutory and constitutional obligation to keep victims apprised of developments in their criminal cases. Mr. Colangelo reports that he will be bringing out a brand new criminal justice database at the first of the year. With that and the discussion, with that in place and based on the discussions we have, Ms. Pierre feels confident that she will have a clear indication of the extent to which prosecutors are contacting victims as required, and there will be a written record of those communications so that the level of compliance can be properly monitored by Ms. Pierre and the members of her office. She does reserve the right to resubmit at a later date, either this proposal or a modified one, if she finds that the practices and procedures we put in place are insufficient, but at this time she does not wish any action taken. And I'm sorry, I don't have it in front of me. I don't know which rule that is. That's 2019-004. All right. So if I don't know the practice of this committee, if anyone has any questions, I would answer them as best I can. If not, I'll move to the to another rule. Chairman.
Let's do those one at a time. First of all, let me say thank you to you, to Attorney Pierre, and to Chief State's Attorney Colangelo. It's always, in my view, better if we can work collaboratively rather than having to impose rules changes to make people cooperate. And I appreciate that undertaking. I know that the Division of Criminal Justice has been working for about 12 years on the development of its electronic case management system, and it's a pretty robust system. So I am hopeful that that the interests of the victim advocate will be able to be accommodated in that manner. Are there any questions for Judge Gold on that item? If not, Joe, let's just put that in, I don't know, park it in a pending list to be addressed at the end of the year at our last meeting to see if any developments have, need to be undertaken.
Okay. Thank you. Yes.
Judge Gold, why don't you next address the discovery issue.
All right. Well, the discovery issue.
I'm sorry, for members of the committee, that's 2019-014.
I really have not too much to report on that, other than this. I've had a number of meetings with members of both the private defense bar and also with Attorney Rapillo, the chief public defender, concerning this proposal. There seems to me, and I only became involved in this, as you know, a couple of months ago, that there still is a significant amount of work that needs to get done in order to have, I think, a consensus reached on this rule. I know that it's been in discussions again for nearly 2 years, if not longer. Something that's complicated it a bit in recent weeks, and I'm speaking now within the last 2 weeks, is there has been a proposal advanced by the private bar requesting that the rule incorporate a requirement that all criminal discovery be provided electronically, rather than as it has been usually with copies being made of police reports. I discussed those concerns with Mr. Colangelo in an effort to see whether there be any resistance among his people to electronic discovery. In the first instance, he did not think it would present a problem, although the ability to do that will hopefully be eased with this case management system that's going to be brought out in the next couple of months. To the extent that there is going to be a rule requirement that there be electronic discovery, that's something that was never before in the rule. So I think that this proposal, which I believe originates from Senator Looney's office, and maybe there's a second legislator, is it Mr. Sackstrom?
No, well, it's both the current and future co-chairs of the Judiciary Committee, as well as Senator Looney.
All right. So one of the things I think is incumbent upon me after I've had these additional discussions, I think they need to be brought to the attention of the the rule sponsors to see if they wish to have any of their views expressed in the rule. But I'm just not in a position yet to offer any specific language to the committee.
Judge Gold, the only thing, I appreciate that update. The only thing I would ask you to do is to reach out to Senator Looney, Representative Staffstrom, and Senator Winfield now, just to alert them that I don't know that we've reported back that we are still actively considering their request. And I think they should be apprised of that so that they know it hasn't fallen off the radar screen.
Yes, sir. I'll take care of that.
Are there any questions for Judge Gold on that item? If not, then let's jump back to 2019-001 regarding the arraignment of a defendant in a medical facility.
All right. Again, this has also been updated, I think, for COVID reasons. This original proposal first surfaced early in 2019. I have materials that date back to February or March of 2019. And we were actually very close to developing some proposed final language for your consideration. We had a meeting actually this morning between myself, Mr. Colangelo, and Ms. Rapillo. And as I indicated, there's been the suggestion raised that rather than having the rule only provide for an arraignment in the absence of the defendant entirely, that the rule should provide for remote platforms to be used so that a defendant who is hospitalized can virtually appear in the courtroom, rather than being a choice that he or she physically be present or be absent. Obviously, there's been a great deal of technological advancement over the last 7 or 8 months as we've dealt with COVID. That's changed the way we do business on the criminal side quite a bit. And there was an opinion expressed by actually both Mr. Colangelo and Ms. Rapillo that we should explore and include in the rule a process by which a hospitalized defendant could be sent an invitation and actually log on through some device and be advised by the judge of his or her constitutional rights. There would be a formal appointment of a lawyer. If we do this, as I hope we could over Microsoft Teams, we could use the FTR platform and actually have it be transcribed by the court monitor. And it would be a much closer substitute for an in-person arraignment than the originally proposed rule would have called for. So we've seen over the last 7 and 8 months some of the ways things can be done. I don't think people really ever thought that carefully about these remote options, but it's seen now a good idea moving forward to incorporate that into the rule. So we've begun working on that. I believe that Kate Kassebaum is on this call as well, or maybe, and she has taken the lead in proposing some language that we hope will carry out our intended goal.
Thank you very much. You know, let me just observe that I would be surprised if the branch's investment in all of this technology is going to remain static after the pandemic is completed. And I would anticipate that other operations of the branch may want to continue to use electronic platforms such as Teams. So as it's beyond the scope of what we have to do, but I would suggest that maybe Judge Gold would talk to Judge Carroll and the other CAJs about whether there are going to be other rules that might need to be addressed in the future to accommodate electronic appearances over Teams. I know we have some, but I don't know that there's uniformity in the process just yet.
Yes, sir. I'll bring that to Judge Carroll's attention.
Are there any questions for Judge Gold on that item? Judge Gold, I appreciate the update on those 3 items, and please extend my apologies to the other members of your other committee about why we've kept you late.
Would you want me to report back on the hospital arraignment and the discovery rule in a month or two?
You tell me what you need. We would normally just carry the item over so that we keep a fire under all of ourselves to keep it moving.
All right. Well, then, may I ask that it be docketed for next month, and I'll report back with whatever additional information I have, or indicate that none has been forthcoming, and I can look for another month then.
Very good. Thank you.
And thank you very much again, Justice McDonald, for taking me first.
All right.
Thank you. Bye now.
Have a good afternoon. All right. Let's go back, and then we have to do the first item, which is the approval of the minutes from the October 19th, 2020 meeting. Is there a motion to approve?
Judge Bella, so moved.
Is there a second?
Second, Judge Cobb.
Is there any discussion or proposed changes to the minutes? If not, all in favor, say aye.
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 Opposed, say no. That passes unanimously. So Attorney Del Campo, help me out on this. For the next item, 2018-003, the proposal from Judge Adelman. Is there anybody going to be addressing the committee on that?
Unless Judge Adelman or Judge Alvis is here, I don't believe so. This was last considered last month, actually, October 19th. After discussion, the committee tabled it until this month for further discussion and for council to prepare a revised proposal. Shauna O'Donnell, Attorney O'Donnell, did prepare the proposal, revised proposal according to what was discussed. Judges, that's the item that you have before you today. Judges Albus and Edelman have reviewed that and support it. The only thing, Judge Albus did not get it in enough time for him to distribute it to the family judges, which was requested of him. He's okay with not having done that, but if you'd like him to do that, he wanted me to report to you that he's more than willing to do that. He just needs a little more time to do that, given when we got it to him. But he is supportive of it. He doesn't think, he's very comfortable with it as it's revised. It's not a huge change from what it was the last time he circulated it. So he's comfortable with whatever you want him to do with it at this point. This was to be one of the last times you wanted to bring this up. So if you want him to send it around one more time, he can do that. Or if you want to discuss it on the merits, he's fine with that as well.
Thank you.
As part of that discussion, one of the points was raised was whether or not the commentary would need to be permanent, as it does explain a lot of the use of the rule.
Thank you, Shanna. So so members of the committee are clear, this is what we're talking about is the revised proposal, letter N, that is on the agenda. I personally am fine moving forward at this stage, but I would defer to other members of the committee if they have strong feelings about this first being circulated to all of the family judges prior to us taking it up. Anybody? Okay, so let's have a motion to approve the revised proposal from council, which is 2018-003 sub N, and then we can discuss it. Is there a motion to approve?
So moved, Avery Whetstone.
Is there a second? No seconds?
Second, Judge Farley.
Thank you, Judge Farley. So let's open it up for discussion. Would anybody, we've talked about this for several meetings, but if there's anything new that needs to be brought to the attention of the committee, this would be the appropriate time. Okay, hearing nothing. All in favor to approve the revised proposal, say aye.
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 Opposed, say no.
No,
Was that Judge Bellis?
it was.
Okay. So that passes. You know what? Let me ask members of the committee. Does anybody know? I should have said this before we voted on it. Does anybody know if Judge Wynn O'Dowd or Judge Prats has strong feelings on the subject? They are not at the meeting today.
I did ask Judge Prats via email if she had comments on any of the proposals, and she only indicated that for the 3 proposals upon which Judge Gold spoke, she was in agreement with Judge Gold's comments and had no other comments.
Okay. I guess, well, we could always reconsider this if their positions are not in alignment with the revised proposal at next month. So that's approved, subject to anybody having a motion for reconsideration.
And would you,
yeah.
and excuse me, would you like the commentary to be permanent? This was a concern because we had placed in the commentary the language, amongst other language, about 4-2, indicating that the attorney, when attorney was representing the individual, that the document had to be signed by the attorney. I mean, it was concerning to the committee that this language be put in here. So we wondered, at least in council, staff wondered whether or not you wanted that commentary to remain permanent. It explained the situation, what was happening, and gave the history of it.
Are there any comments from members of the committee about whether to keep the commentary permanent? why don't we do this? Why don't we, since it is in the proposal that we just voted on, we'll leave it in right now as permanent. And if anybody has a change of heart, as I said, it could always be the subject of a motion for reconsideration at our next regularly scheduled meeting. Is that okay with everyone? Silence is acquiescence. Okay, thank you, Joe. The next item then is 2019-16, I believe. I'm sorry, folks, I'm trying to jump back and forth between documents. Right, this is the proposal from the judicial branch related to MCLE requirements. Yes. Joe, could you bring us up to date?
Yes, this was considered last in September, on September 14th. After discussion, the committee tabled it and instructed me to circulate it to the revised proposal to all county bar associations and to request their comments. It had been some time since we had received comments, so you wanted to make sure everybody was aware of it. The proposal was circulated as directed. We did only receive comments back from the Harford County Bar Association, which are in addition to all the other comments that we had received. Mike Bowler is on the call. He's available to you if you have questions. Again, this proposal has been around for a little bit of time and is pretty much, we have exhausted the individuals, I think, to whom you wanted it sent to.
And I just want to be clear, Joe, we are talking about 2019-16L. Is the proposal?
Yes.
Okay. Attorney Bowler, if you are on the call and would like to address the committee, now would be the time.
Yeah, I don't really have any further comments on it, Your Honor. In reviewing the Hertford County Bar Association's comments, it seems that they were generally supportive of the rule changes. Their only concern was about whether notice, sort of the last notice to the lawyer as they were approaching their suspension date, should be hardwired into the rule or should be left to, I guess you would say, my office's discretion. My only comment would be I'd recommend the latter. Both my office and the Client Security Fund, which I oversee, also send out multiple notices of this type every year. None of them are hardwired into the rule. We simply calendar for them. It had been my thought that if the lawyer's license was in jeopardy by December 31st, they would get a notice by email no later than October 1st, notifying them of the December 31st deadline. That would give them 3 months to catch up with their CLE. But other than that, I think I've sort of exhausted the administration's position on this and appreciate you giving me the opportunity to say one last bit about it.
Thank you very much. Are there any questions for Attorney Bowler from members of the committee? If not, I would accept a motion to approve 2019-16L, the revised proposal.
So moved. Judge Cobb.
Been moved by Judge Cobb. Is there a second?
Second, Avery Whetstone.
Thank you, Judge Avery Whetstone. Is there any discussion by members of the committee? If not, all in favor, say aye.
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 Opposed, say no. That passes unanimously among the members who are present. The next item is 2020-8, the proposal from the CBA Pro Bono Committee and the Standing Committee on Professional Ethics. And there's a revised proposal from the CBA, that's subsection E. Joe, would you care to bring us up to date?
Sure, that was last discussed by the committee in September. After that discussion, it was tabled until this meeting to allow Attorney Bowler to bring the revised proposal to the statewide grievance committee for consideration at its October meeting. That has happened, and Attorney Bowler did bring the comments forward. Those are the ones that are here for consideration today. Again, Attorney Bowler is here. He could bring us up to speed as to what those comments were, if you want a summary of that.
Yes, please, Attorney Bowler.
Yeah, it was, the committee didn't have much more to say than it did the original time, in its original comments. The new proposal continues to keep the procedure and the rules of professional conduct. The committee is concerned about that. They believe that a procedural rule should appear in Chapter 2 of the practice book and not in a rule of professional conduct. The committee noted that the multi-jurisdictional practice procedure is in Rule 5.5, but unfortunately that rule amendment was passed back in 2007 when it wasn't the Rules Committee's practice to forward these proposals to the statewide grievance committee and other interested stakeholders for comment, because we would have told you the same thing we're telling you now, is that it probably belongs in Chapter 2 and not in Rule 5.5. So the proposal continues to keep the procedural rule in a rule of professional conduct. We would recommend putting it in Chapter 2. Wherever the committee deems appropriate. If you want a recommendation from me, I'd be happy to look through the practice book and give you a recommendation. Our only other concern, and it's a relatively minor one, is that the rule proposal, it's a laudable goal, but it does use some language that may be unique terms of art to the state of Connecticut. So it talks about if a lawyer being allowed to practice pending admission if they have not resigned in the face of a disciplinary action in another jurisdiction. Well, that's a Connecticut specific term. Not every other jurisdiction necessarily uses resignation for when a lawyer voluntarily gives up their license in the face of a disciplinary action. So it's hard to compare apples to apples in the proposed rule, which is trying to weed out sort of bad apples who we don't want here practicing maybe at all, never mind pending admission, with other jurisdictions which use use terms that we use in Connecticut, but they may use it for a different reason. I'll use resignation again as an example. In the state of New York, you can voluntarily deactivate your license by resignation. In Connecticut, we call that retirement. And so my only concern is when you use terms of art like resignation in the face of discipline, a state like New York might call that something else. A state like New Jersey might call that something else. So again, it may seem a minor quibble and something we could work out when interpreting the rule, but the committee did also have that concern. So our first one is that this really belongs in Chapter 2. And second, the committee was a bit concerned about language that may not find a parallel structure in Connecticut.
Can I ask you, is your recommendation about it being in Chapter 2, is that to the exclusion of it being in the rules of professional conduct?
Yes, because it talks about how you can practice pending admission. And so there's nothing wrong with the procedural rule saying, notwithstanding the provisions of Rule 5.5 of the Rules of Professional Conduct X. So for instance, for foreign legal consultants, for hoc vice attorneys, et cetera, all of those rules for those folks, authorized house counsel, all those people who are not admitted to the Connecticut bar, how do they obtain practice privileges in Connecticut? It's through a procedure set forth in individual sections of Chapter 2 of the practice book, as opposed to being hardwired into a rule of professional conduct.
Okay, and I know it appears that we have Attorney Stovall on the call as well. Attorney Stovall, would you care to comment on this?
Yes, Your Honor. Thank you for the opportunity. First, I just want to address one minor thing that Mr. Bowler said about practice pending admission. The 5.5 pro bono proposal doesn't have anything in it about practice pending admission. It's just a proposal to amend Rule 5.5, which already contains many categories of practice in Connecticut that are permitted by attorneys licensed in other jurisdictions. So while it's true that the chapter 2 of the practice book does establish the procedures for admission in Connecticut, 5.5 is really geared to something different, because 5.5 starts out as a rule saying that the unauthorized practice of law in Connecticut is a violation of the rules of professional conduct, or to assist someone in practicing and engaging in unauthorized practice is a violation of the rules of professional conduct. The rest of the structure of Rule 5.5 is a set of very discrete and very specific categories of practice that are permitted in Connecticut by attorneys who are licensed in another jurisdiction. And the current pro bono proposal is simply an addition to that scheme, and it's structured similarly to the way the other exceptions to unauthorized practice by attorneys licensed in another jurisdiction in Connecticut. So at least for the issue of whether it should be in Chapter 2 or in Rule 5.5, there are a number of reasons. There's at least one reason why it makes sense to put it in Rule 5.5 is because an attorney who's licensed in another jurisdiction will know, based on the rules of professional conduct in that attorney's jurisdiction, where to go look for the exceptions to the prohibition on unauthorized practice by attorneys licensed in another jurisdiction. An attorney from outside the state might not necessarily know to go look in Chapter 2, whereas would be able to look at the rules of professional conduct to the extent that they're comparable in that attorney's home jurisdiction. The judges adopted the scheme of Rule 5.5 13 years ago, following the ABA, which made the determination that it was appropriate to have the whole scheme in the rules of professional conduct. That's what happened in Connecticut. I don't see any reason why the new proposal doesn't fit very neatly in the set of circumstances already listed in Rule 5.5 that permit practice in the state by an attorney licensed in another jurisdiction. To the second point about the specific language about resignation and from the bar, it would be almost impossible, I think, to draft a rule that would be able to take into account all the different permutations of resignation or retirement from the bar in different jurisdictions. What I want to note is what the rule essentially provides is that only an attorney who is either in good standing or who retired from the practice of law while in good standing is permitted the privilege of this form of practice in Connecticut, even though not licensed in the state. And then there's a further, the word that seems to trouble Mr. Bowler, the grievance committee, is within the definition of what good standing means. So I'm not entirely sure I understand how the concern that Mr. Bowler has expressed would play out as being problematic, but I think the rule overall contains quite a number of the proposed rule, a number of safeguards that would prevent practice by someone who wouldn't be qualified under the rule to legitimately engage in pro bono practice under the proposed exception. And one of the main ones is that the practice is only permitted if the work is undertaken in association with a Connecticut attorney, another with a legal aid society or a specific bar association pro bono program. So there are, as drafted, there are a number of safeguards. The whole structure of it, in fact, is to make sure that only attorneys who are in good standing, working in conjunction with a Connecticut organization, would be providing pro bono services in Connecticut under the proposed exception.
Okay, let me ask Joe or Shanna, is there anybody else that has requested to address us on this subject?
No, I don't believe so. Not formally, no. There are many comments here, but no.
All right, so let me suggest, and obviously any members of the committee, if you have a different idea, please speak up. But when I was a young attorney, a judge who is still on the bench said to me that when there is a situation such as this, people of goodwill can go away and come up with an agreement. And if you can't come up with an agreement, the judge will be forced to make a decision, but it's always preferable if the two sides can come up with an agreement. Is it possible for Attorney Stovall and Attorney Bowler to sit down and hammer something out that would be acceptable to both of you, or is this something that you just need us to have a binary choice and pick one out or the other?
Well, I'll speak for myself, and I appreciate Attorney Stovall's comments, and I have to admit she's starting to persuade me a bit. So I would, and she and I have worked on more than one project together, or at least sharing information about the disciplinary process. We've worked, I don't know, or seen many years together on different projects, and I'd be happy to, if we could perhaps table this for a month or so, I'd be happy to reach out to Attorney Stovall, and I'll probably end up capitulating, but at least I'll at least I'll let my committee know that I'm doing it before I do it.
So let me make a suggestion that because a month from now brings us into December, let's just table this for 2 months to give everybody enough time to really hammer out what will hopefully be a final product that you can get, if you can do it, get to our staff at least 2 weeks before our meeting in January, so that we have enough time to review it before our meeting in January. Does that sound acceptable?
And again, it was acceptable to me. Marcy, I assume it's acceptable to you to give me a call.
Of course it's acceptable to me. I'm completely confident that Mr. Bowler and I can work something out. And I think if it was just up to the two of us, we could probably get you something before the December meeting. But since I know he probably has to go have some feedback with the grievance committee, it probably makes more sense to wait to put it off until January.
Agreed.
Okay, thank you very much. Is there any objection to that,
Your Honor.
members of the committee? Okay. Next item is 2020-10, the proposal from Judge Stevens to amend section 13-14 of the practice book. Attorney Del Campo?
Yes, this I believe was first considered by the committee in September. It was tabled to seek comments from Judge Abrams, the Connecticut Bar Association, the Connecticut Trial Lawyers Association, and the Connecticut Defense Lawyers Association. Judge Abrams did comment, as did Attorney Harris and the CTLA, let me just see, and the CDLA. I don't believe we got comments from the Connecticut Bar Association on this, but we have 3 or 4 sets of comments for consideration today. You've never discussed it on its merits before.
So my recollection is that we had asked Judge Stevens to be an ad hoc member to help continue to lead this. Is that a mistaken impression? Does anybody remember that? Okay. All right, then I guess I must be thinking about something else. How would, I don't have any clear direction about how to proceed at this moment. Does any member of the committee have any suggestions? No?
Excuse me, this is
Yes,
Judge
Judge
Farley. Well, I would have to say that I agree with what the CTLA said, that if not, if language should be taken out. Otherwise, I agree with the comments that we received, and I would say we don't need that last sentence that's been proposed. I think we could vote on it. I'd be ready to vote on it on those terms. If other people feel differently, I'd be happy to wait.
I just want to make sure we're all clear on what you're recommending, Judge Farley. So just say it one more time, please.
Right. So the Trial Lawyers Association agreed that we could add as one of the options that a trial judge has entering an order of compliance the proposed language says, if not yet issued, and that language suggests that only one order of compliance could be made, and there may be a reason to enter successive orders of compliance. So I would agree that that should be deleted, and otherwise I would not. I would also delete the proposal, the last resort proposal.
Okay,
I
so
agree with
you would delete, and you would delete if not yet issued.
Correct.
Okay. I take that as a motion
I would move that. Yeah.
with that modification. Is there a second? Is there no second? Why don't we, hold on, give me 1 second. Joe, I'm just trying to put the timeline together here. Did the CDLA respond to the CTLA's proposal?
Just a second.
I'm looking at, hold on, their letter is November 6th, and
No, we put out the referral simultaneously, so they just come back when they come back. They don't have knowledge of the others' comments until they see them when they're on the agenda. So they're not coordinated in an intricate manner. They're just coordinated to just refer it out, and then for the committee's edification, they come back. They don't copy each other on the comments, and we haven't done that unless they were asked for it, which I don't.
Do we have anybody on the on this call from the CDLA that is prepared to talk about this?
Yes, Your Honor, Erica Amaranti is here. If I may be heard, I raised my hand. I don't know if I needed to do that.
No, I appreciate that. I'm just trying to navigate a lot of different aspects of this, so I'm glad you jumped in. But I appreciate you raising your hand. Please proceed.
Okay, thank you, Your Honor, and thank you to the members of the committee for letting me be heard today. Our letter set forth the CDLA's position, which is really twofold. First, that it's not clear what the impetus for the rule change is. In other words, what is it that we're trying to fix that doesn't work with the current 13-14, which seems to us already to include case law that establishes that the remedies of non-suit and default and dismissal are rarely granted, and the case law sets that forth. And then the second concern was just that adding the language about the remedies being of non-suit and dismissal and default being a last resort threatened to potentially take away some of the trial court's discretion when the trial court knows the parties and the case much better. I did not see the CTLA's letter until just a few hours ago today. And I do agree with their proposal about taking away the phrase, if not yet issued, because an order of compliance isn't just a one-time thing. I do agree with that, but I stand by the comments that we're not entirely sure that this rule requires an amendment at this time. Thank you.
Thank you. Let me, and forgive me, I know this has been kicking around for a little bit, but have the CDLA and the CTLA just been going through the committee, or have you been talking directly to each other on this subject?
We have not been talking directly to each other, Your Honor, which we are happy to do.
So that's what we're going to do, right?
If I may, I'm Stephanie Roberge is on the call as well. From
okay, thank you.
I just there I am.
Yes. So would the two of you be willing to connect up and talk about this so that we can hopefully get a product that is acceptable to both groups?
Absolutely, we can speak, Your Honor.
Yes.
Okay.
Happy to.
I mean, I appreciate the comments, and we did ask you to send them to us. It's never intended to mean that you can't talk to each other, and that oftentimes saves a lot of time if you can do that. If you could do that, and I will do the same that I did with the prior item, do you think you would need a couple of weeks or for us to have it on for December, or do you want to have some extra time and then we would take it up again in January?
If you don't mind, would January be okay with the committee? Is that okay, Erica?
Yeah, that's fine with me. Yes.
I don't think you're going to get any objection from us. If you can work it out, it would be, the time would be well worth the investment. Okay, Judge Farley, will you withdraw your motion at this time?
Well, it wasn't seconded. I'm not sure I even have to, but if that's helpful, yes.
Otherwise, it would have to be defeated. I don't want you to have a defeated motion, so it's withdrawn. Okay.
So that was,
okay, and I thank both of you for cooperating and helping us to try and resolve this issue. The next item is 2020-12. It was a proposal that was originally filed by Attorney Megan Wade, and it's been amended or substituted with a proposal by the Connecticut Bar Association regarding a proposed change to the Rules of Professional Conduct 8.4G. Let me just perhaps state the obvious. Since our last meeting, we opened up the opportunity for individuals or organizations to provide additional material to us for the committee's consideration, and many entities and organizations took us up on that opportunity. We have been provided with a substantial and voluminous amount of those materials, some of which have been coming in, I think, as recently as today. And a couple of members of the committee have indicated that they have not had sufficient time to review thoroughly all of those materials. It would be a disservice, in my opinion, for us to try to move forward with any meaningful discussion about the subject until everybody is up to speed, and frankly, until we have a full complement of members of the committee, including Judge Wynn O'Dowd and Judge Prats. So I don't think that we can do any official action on this item today, but I am obviously willing to have members of the committee talk, and maybe have a very limited amount of additional input from anybody who has previously contacted Attorney Del Campo to talk on this subject. But first, let me ask members of the committee if that proposed course of action makes sense. I'm sorry, I should finish my thought. What I was thinking, because we are still getting comments in, is that we would perhaps give another week for individuals or entities to provide their written comments to the committee, and then have a firm cutoff at that time, so that we have an adequate amount of time to review these submissions. Some of them are 40 and 50 pages long, and we need to have a hard deadline so that we can actually review what we've gotten. So that would be my proposal, that we not have any kind of official action on the item this month, but rather give an additional week of comment and then have a firm cutoff where no comment would be accepted after that point in time, so that we could take this up in our December meeting. Does that sound like a course of action people can align themselves with, or no?
Sounds good.
That was Judge Bellis. Judge Cobb, I see you engaged your camera. Would you like to?
I think that sounds perfectly fine. My only concern is that if there is someone on the call today who wanted us to hear from them and couldn't come back, that we allow that person to speak. I don't know that that would impose a problem with not seeing all the comments first, but.
So that's a good point. Let me say that, we have normally been very easy about allowing anybody to address us on a subject. This item has resulted in more than 40 submissions to the committee. I don't want to have a long discussion this month that is going to be replicated next month when we might be in a position to take more definitive action. And I should point out, even if we did take any kind of definitive action, if it were to be adopted by the committee, it would still be the subject of a public hearing later in 2021 when anybody could come to the committee and talk. So I don't want to open this up to a big discussion now when we'll have a big discussion next month and then a public hearing where there'll be another big discussion about it. But your point is well taken. If there is anybody who has been patient and waiting today, if you would like to talk to the committee for 2 or 3 minutes and you are representing that you are unable to attend next month's meeting, then I would accept that representation and allow you to address the committee. Attorney Bowler, do you have your hand raised to talk on this subject?
I do, Your Honor, just briefly, and that is, I last attended the Rules Committee meeting in September, and at that time only Attorney Wade's proposal was before the committee, but there was discussion that the CBA would be filing its substitute proposal. Neither the statewide grievance committee, and I don't necessarily want to speak for the Chief Disciplinary Counsel's office, but I believe Brian Staines is on the call. Neither his office nor mine got a referral from the Rules Committee to comment on this proposal. And if you don't want to hear from us, that's
that's even more reason to not move forward right now. That was, I will say this this proposal took on a life of its own.
I understand.
If that was an oversight on our part, I apologize. It should have been, the modified proposal should have been referred to both of you. So my only caveat is I unfortunately I won't be able to get this to the committee until its December meeting, which is the third Thursday of the month, which is probably going to throw a wrench into your plans to have this on next month's agenda. This is a big issue, and I normally I might say to you, well, I'll just do an email, but I really think this is something where I need to have a call or a formal meeting with the committee. We're going to need to do some research on it. I know it's sort of it's a question throughout the country that a lot of jurisdictions are struggling with. I don't want to say, can we have it on January? But if you want a thorough response from the statewide grievance committee, I just don't think I'll be able to get you one before the December meeting of the Rules Committee. And again, I don't want to speak for Brian, but that's my problem. I don't speak for me, I speak for the committee. Brian, are you available to address that issue?
Yes, I agree that this is a very important issue, and I've had the opportunity to review all of the materials that have been submitted that I've reviewed so far. I would like to get the input from the full statewide grievance committee after they've had an opportunity to consider it before I issue my opinion on this and comment.
All right, let me ask Attorney Del Campo, remind me again, our last meeting for taking any action is which meeting?
Usually March, yes.
Is there's some built-in buffer there. So with that understanding that nothing, there's no drop dead date until March, is there any objection from members of the committee to extending this to the January meeting? In which case I would probably say that what's the date of the January meeting, Joe?
I don't have it here. I'm just 1 second. Shauna, might you have that up? Let me see.
The meetings that are, sorry, the February meeting is the 8th, the January meeting is the 11th.
Thank you.
So January 11th, 2021.
All right, so if that's the case, why don't we, unless there's any objection, why don't we extend the comment period, if we're going out another month, to the close of business on December 4th? That's a period of time.
I can only just say the next committee meeting is
Not
December 17th. Okay.
Not for you.
Okay. I have something to see you by the end of the year, just not.
Yeah, no, not for you. I'm talking about bar affinity bars or individuals, members of the public, having that as the deadline for submissions. Does that seem fair to everyone? And then we'll have plenty of time to look at those submissions and then supplemented by what Attorney Steens and Attorney Butler are able to provide us from their efforts. Okay. Is that acceptable to everybody?
Yes. Justice McDonald, just a question, Judge Cobb here. Now, how will the deadline to the public be noticed? Would we put it on our website or? So
I would suggest, well, first of all, this meeting is being live streamed on the branch's YouTube video. I think we could also put it on our website. We can have our Director of External Communications put something on the branch's general website. And I know that the Connecticut Law Tribune has been following this issue closely, and I suspect this issue will be well publicized about the deadline.
Okay, and I wonder if Joe wouldn't mind telling us the list of people who received notice of it specifically, so that in the event there's anybody else we can think of, we could send out notice now.
Okay, we can get you that. We have that. We did put it out to the affinity bar associations. We worked with the CBA on that and the different local bar associations. And then some of this list is individuals who just sent their own comments after being affiliated with one of the other groups. So yes, we can get that to you.
Is there any other governmental agencies that we would want to include? We have the grievance panel, the disciplinary council. I'm just thinking.
I would note that the most recent letter that was received, which was signed by the CBA and a number of organizations, did include a bunch of different groups that we had not solicited comments from. We also did receive comments from all of the affinity bars and the Attorney General's office.
Okay.
Is there anything further from members of the committee? If not, then we will proceed according to that schedule. Okay. All right. And then the next item is 2020-13. It's a proposal from Judge Noble to amend section 10-60 concerning amended pleadings. Attorney Del Campo?
Yes, that was last considered last month in October. The committee tabled it for us to prepare a revised proposal, which Shauna has prepared several different amendments to several different rules. We were to provide the proposal to Judges Abrams and Albus and to request their comments. Judges Abrams, Albus, and Noble have reviewed the revised proposal and support it. So that's what you have before you today. There are three different rules, I believe, that were amended. One additional rule was suggested, but we chose not to amend that. So that's not in Shauna's revised proposal. But again, Judges Abrams, Albus, and Noble have reviewed Shauna's revised proposal and support it fully.
And if I recall correctly, this was effectively submitting the red line version of the amended pleadings
Yes.
for both family and civil matters, right?
Yes, sir.
Okay. Have all of the members had sufficient time to consider the revised proposal and the comments from Judge Albus and Judge Abrams and Judge Noble?
Yes.
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 Okay. Is there a motion to approve the revised proposal?
So moved, Judge Cobb.
Is there a second?
Second, Judge Bellis.
It's been moved and seconded. Is there any discussion? All in favor, say aye.
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 Opposed, say no. That passes unanimously. The next item is 2020-19. It's a request from the Office of the Chief State's Attorney to reinstate Section 38-21, subsection B. This is the first time that the matter is being considered. I will confess I didn't get off the bench until 1:30, and so I did not have an opportunity to review this. I'm not even certain what it covers. Joe?
Well, this is a request by the Chief State's Attorney's Office to reinstate 3821, which was suspended based on your emergency powers. And then ultimately what that was adopted by the full bench in the judge's annual meeting. So I believe that this request is misplaced with the Rules Committee, because I believe what the state's attorney is talking about is the actions that are taken under this new rule that you adopted and the judges enacted, which is 1-9C, which allows the various chief administrative judges, in cooperation with with Judge Carroll, the chief court administrator, to suspend any of the practice book rules. Justice McDonald will remember this. This was proposed, I believe, on your behest when you were undertaking your emergency powers, such that adjustments could be made without coming back to the Rules Committee under emergency powers all the time. So this procedure was adopted. So the only way really at this point in time to immediately suspend or to bring back one of the rules that was suspended is by this process. And it was done recently by Judges Albus and Abrams for defaults and non-suits. Those group of rules, there were two of them, were brought back. Basically, the suspension was suspended so that they are now in effect. And there was a carve out to one of the executive orders that judicial proposed to the governor's office that allowed any statutory suspensions of defaults to come back. So this is why we're having defaults now in court, which were suspended for a number of months. But my point is that I believe that this has to be taken up with Judge Gold, if anyone. I don't believe that the Rules Committee.
Right. So forgive me. I didn't recognize it by the title on the agenda. I'm now looking at the letter. I remember receiving this letter and reading it at the time from Deputy Chief State's Attorney Lawler, who I believe is on the call. And Attorney Lawler, if you would join us with your video, that would be helpful. Are you still there? Okay. This would have to follow the same procedure as we did with the defaults. Do any members of the committee have any questions or concerns about proceeding in that manner? Okay. So what do we need, Joe? A motion to?
I think you need probably to take no action on it, but I can.
So just send it to Judge Gold?
Well, I can write back to the Chief State's Attorney and suggest that they raise it with Judge Gold, or I can write to Judge Gold, however you want it. You could refer it to Judge Gold, I suspect. I can write to him.
Yeah, why don't we send it to Judge Gold? And I thought Attorney Lawler's not on the call anymore. Just make sure he's aware that that's the direction we're going in at the moment. Okay?
All right, I will do that.
Is that acceptable to all the members of the committee? Silence?
As long as the referral doesn't say anything about whether we take a position on it.
No, it won't. It's just for his comments to members of the committee. Okay. Is there anything? Go ahead, Judge Cobb.
I guess it seems to me that at this point, the letter should go back to Attorney Lawler for if he wishes to raise it with Judge Gold. And then if Judge Gold wishes to raise it with us, then it would come through the administration the way the non-suit one came in civil, because it's not really for us to do unless it comes through the proper procedures of the administration under the rules that were adopted.
Technically, you're correct. I thought it would be just a little more efficient to just say, does Judge Gold support the proposal or not, which would get us to the same place. But I think technically you're accurate.
So that's what I would prefer that we do. But
okay, we will do it by Hoyle. Very good. Is there any objection to proceeding in that manner? Okay, thank you. Is there any other business that needs to come before the committee? If not, is there a motion to adjourn?
So moved, Judge Bellis.
Moved by Judge Bellis. Is there a second?
Second, Judge Cobb.
Second, any discussion? All in favor, say aye.
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 Any opposed? That passes unanimously, and I thank everybody for their time and attention and the cooperation of everybody who's helping out the committee discharge its responsibilities. Take care and be safe.
Thank you.
Thank you.
Happy holidays.
Thank you.
Thank you, Your Honor.